Hello, Eric Smith here with Bar Exam Review, and we'll go over an MBE style multiple choice question shown on your screen. Here the question is, victim claims that defendant robbed him by first threatening him with a gun and then yanking a box out of his hands. Eyewitness testifies that no gun was ever visible. The question is, defendant can be tried for A. Robbery only, B. Larceny only, C. Robbery or larceny, or D. Robbery and larceny. So here we have a fact pattern that leads us to look into the larceny area, and for that we have this particular page in the book Bar Exam Review Complementary Model-Based Systems Engineering of Law, and we see that what this page looks at is larceny and related crimes. Now larceny here is the base crime, and is actually described at the bottom of the page because it is the base crime. It says here that larceny, the things that the defendant must do is take property with trespassory intent, and further acts that the defendant must do, the further act is to deprive the victim of such property and also have intent to deprive the victim of such property. A quick summary of what larceny is here. Larceny is the trespassory taking and carrying away of the tangible personal property of another with the intent to permanently deprive that person of their property. Okay, so there's the act of taking and further the act of depriving, both of which must be done with the intent to take and then the intent to deprive. The reason why these bubbles are shown from left to right is because time-wise, usually the taking occurs first and then the further deprivation of the property from the victim occurs second, and that's the base crime of larceny. Now, a crime that's based on larceny is what is of interest in this fact pattern, and that is the crime of robbery. And here we have that robbery is the larceny by force or apprehension. So in order to commit robbery, a defendant must first have committed larceny, and it must further be done by force or by causing apprehension or fear in the victim. And so the crime is described here in the bubble diagrams. The defendant must commit this action, apply force or threats, with larcenious intent. That is, the defendant must have committed larceny, must have intended to commit larceny, and must further have done that with the physical acts of force or threats, and have done this on the victim. The victim doesn't have to have done anything. It is just shown here as an empty bubble diagram. So we see that larceny is the base crime, and robbery only occurs if the larceny is committed by force or threats. Now, the fact pattern here leads us to a certain rule, which is described on this page, and this page is rules of criminal law. These are important rules that come into play when analyzing crimes, a number of crimes that may have been committed together. And we have a number of rules on this page. Number one is the merger doctrine at common law. Number two is the Blockberger rule. And number three is the red line rule. These are all summarized on this page. The rule that is of interest here is the merger doctrine at common law, the doctrine of lesser included offenses. And what this rule tells us here is that in the parentheses we have that this crime will merge with this crime if they both occur together. That is, the lesser included offense, the lesser offense, will be included in the greater offense if the greater offense is shown to have existed. And so we see here five 5 instances of lesser included offenses and the crime with which they will merge. Of course, the one that is of interest to us here is the fact that larceny is a lesser included offense with robbery, according to the merger doctrine at common law. So what that says is we may have all the elements of larceny in place, and the defendant can be convicted of larceny. And if we have the further facts and the fact finding by the jury that the greater crime of robbery took place, and the defendant can be convicted of robbery, then according to the merger doctrine in criminal law, the lesser included offense generally merge with the greater offense, and that means that the defendant will only be convicted of robbery and not of larceny. So these are the 2 pages important to analyze the facts in the question. And so if we go back to the question, we find here that the correct answer is C, robbery or larceny. And the reason for that is that the merger doctrine at common law prevents the conviction of both crimes, and so that means that both crimes cannot be found. The defendant cannot be convicted of both crimes according to answer D. Now, the fact pattern leaves open the fact that the jury will look at the evidence and decide whether they believe the eyewitness who says that no gun was ever visible, or the jury may believe the victim who says that the defendant robbed him by first threatening him with a gun. So depending on who the jury believes, the victim or the eyewitness, the defendant can be convicted of robbery or larceny. And so C is the fuller and more complete answer. Answer A and B are too restrictive because the jury has as its option to convict of perhaps larceny only, perhaps robbery only, but they certainly have the jury certainly has the choice of convicting of either robbery or larceny. Answer C is correct.